Hello, this is Keith.
Excellent. I believe that means we have a quorum and we can get going. Tana, first thing on the agenda I see is an official call to order and roll call.
Yes,
Would you be kind enough to do that for us?
certainly. Mr. Straight,
Present.
Mr. Feller,
Present.
and Mr. Soboleski.
Present.
Okay, for staff, Mr. Dole,
Present.
Mr. Heil,
Present.
Mr. Hickle,
Present.
Mr. Cleek,
Present.
Mr. Owens.
Yes, I'm here.
All right, and Mr. Stewart.
Present.
Thank you. You have a quorum, Mr. Chair.
And can we get anybody whose name was not mentioned in that roll call, could we get you to speak up so that we know who all we have on the line?
Okay,
Mike May. Sorry.
go ahead.
Mike May, code abatement officer. Also SMJ.
Okay, and just listening in is JC and his father from Tent City.
Correct.
All right,
Correct.
thank you.
All right, before we dive into this, Tana, would you go over anything that's different from our normal meeting process in that, technically in that aspect? Normally we're all in a room, we're recording. I assume we're recording this. Is there anything else different from a normal meeting that we should be aware of?
No, it's going to be kind of run like normal. When the time comes, we will put up on our screen so that you can see documents.
And any documents you will be putting up would be part of the meeting packet that's been sent out previously, is that correct?
Yes.
Yes.
All right. And one last thing before we dive in, is there any questions from anybody on the line, any other panel members, anybody have any concerns or curious about how this is going to go? Okay. And as Tana said earlier, if you're on the telephone and you're not talking at the time, please hit the mute button so we don't have any feedback coming through or any unnecessary sound. And with that, we will move on to item 2 on the agenda, new business. And we're here to, it's a 3-member panel hearing for, I believe it's case number BCA Bravo Charlie Alpha -03-2020. And this is the appeal of the building official's decision of notice and order and notices of violation of license. So the first thing I'm going to do, if you're not aware, my name is Sterling Straight and I am chairing this 3-panel commission. Other members of the building board that are on the panel with me for this decision are Troy Feller and Keith Soboleski. So thank you all very much for your time today. First thing I'm going to do is run through real quick a summary of how this whole process is going to go, the hearing process. And if you have any questions at the end of that about what we're doing, again, we'll have a chance to ask and clarify, and then we'll dive into it. So the first step will be, and for the record, I am reading this out of I believe it's the Administrative Order of Business for Appeals, if anybody's curious. And that's section 23.10.016. First, I'll introduce the case and explain the procedure, which we're doing now. We'll read into the record the appeal case number. We've done that, and the name of the party appealing. We'll get to that in a minute. Then, all testimony in this hearing is given under oath. So I will ask everybody who is going to talk to swear to the affirmative. They will be giving the truth before we move on from there. Then the staff, the MOA staff, will give a very brief outline of the case. This is the 30-second version to kick things off of why we're here. And then we will go into the appellant. The appellant will have the chance to give their presentation first. Appellant, any witnesses, and talk through why we're here today. After the conclusion of the appellant's presentation, the staff and any witnesses they choose to call can make their presentation. Both the appellant and the staff, in addition to the board, can ask questions through the presiding officer, through myself, at the end of each presentation. Once the staff is given a presentation, the appellant will be given the chance to rebut, to reply to anything that is brought up. Of note, all parties may be presented by legal counsel. I don't know why that goes up in the middle of the procedure, but hey, there it is. The burden of proof does rest with the appellant, so it's the duty of the appellant to make the case for why we should consider their appeal, why we should reverse the decision of the board. Upon us, the burden of the proof does rely on the appellant to make the case. So we'll be very interested in the appellant and their presentation to hear that. Finally, we will then, once everybody has made their presentations, all questions have been asked and answered, our three-member panel will then discuss amongst ourselves, and there will be a official motion and second and decision on whether or not to accept the appeal. At that point, that decision will be made. The finding shall be stated as a specific finding of fact. The affirmative vote of a majority of the three-member panel is necessary to grant the appeal. So today we have obviously a three-member panel, so 2 affirmative votes supporting the appeal will pass it. It will go forward. If it does not pass, I will then, I can say it now. If it does not pass, there are additional appeal provisions that go beyond the scope of this panel. You would have the option to appeal it to the full building board, and from there, I believe it would go to the Court of Appeals. So that's a brief rundown of what we'll be doing. Any questions before we move forward? Hearing none. Again, for the record, we are hearing.
I do have a question.
Go ahead.
This is John Parr for SM or SMJ. There's 2 very similar names, but there's somebody listening in from Tent City, and my client is unclear on why they're listening in.
Because this is a public meeting and anyone and everyone can listen in.
Okay, well that answers my question then. Thank you.
Shannon, will there be a published list of attendees along with the minutes from this meeting?
Yes, there will be. They're more like the decision, but I will add the attendees into that decision.
Okay, that would be helpful for any time we want to look back and see who's here. That way we have that for the record. Are you comfortable with that, Mr. Parr?
Yes, sir. Sir.
All right. Well, we will dive into this, and as mentioned, we're hearing Building Board case number Bravo Charlie Alpha -3-2020. This is an appeal of a decision emanating from the action of the building official, and the appellant, as I understand it from reading the appeal form, is SMJ General Construction. Is that correct?
It's a corporation, or it was a corporation, so it has ink on the end of it.
Okay. The next step is, as a reminder, all testimony that is given today is under oath. And so I'm going to ask everybody who believes they will be giving testimony today to answer the affirmative after I state the following. Do you affirm under penalty of perjury that the testimony you are about to give in the matter before us is truth? If you do, please say aye.
Aye. Aye.
All right, so let the record show we heard a lot of ayes, and we are moving forward on the assumption that anybody who testifies has affirmed that they will be telling the truth under oath. Okay, next up, could I get the staff to give a very brief outline of the case? Please keep it to a minute or less. We don't want to get into the details. You just want to give us an overview before we let the appellant give their presentation.
This is Don Hickel. I'm the Chief Structural Inspector and Code Abatement. We're here for the appeal of the 6 notice of violations for permit and license requirements and the 1 notice and order issued by the MOA to SMJ General for the wine house located at 3020 Minnesota Drive, Suite 1. The MOA permit was C19-1407. MOA believes that SMJ General was the contractor for the project as indicated on the permit application.
All right, thank you very much, Mr. Hickel. All right, for the appellant and whoever you have presenting, this is your chance. Please go ahead and give us your presentation.
Well, we'd like to start with the testimony of Daniel Cliff, who applied, and it was a clerical error. It should have been applied for by SM General Construction, which is Connie Chung, DBA, SM General Construction, which really replaced SMJ General Construction Inc., which was Tyson Chang's company. The reason for that was that SMJ General Construction Inc. filed bankruptcy in 2018 as case number 18-340 and is still in bankruptcy. Bankrupt company literally cannot conduct business. So the business went out of business and was taken over by SM General, Connie Chung, DBA, SM General Construction. And Mr. Cliff went to apply for permits and a clerical error applied under SMJ General Construction rather than SM General Construction. And we have them available to explain that. And then the rest of them we can go through one by one. So we're calling them up now. Here's one of the permit applications right here. Mr. Cliff, this is John Parr. Can you hear me?
Yes, you can.
Okay, hold on. You're actually in front of the board right now. And so we'll swear you in and then take some testimony from you.
Excuse me, he should have called in on the normal line or through Teams. We did not know he was going to be here, and he was not officially sworn in when he should have been.
Okay.
So I'm not sure how Mr. Straight, the chair, would like to take this.
Would it be possible to have the gentleman giving the testimony call into the direct line, partially so we can get him sworn in, but more so technical wise, it's going to be very difficult to hear him on a phone, over a phone line.
Yes, could you have him call the 888 number?
Okay, what's the 888 number?
888-572-6067.
Okay. Mr. Cliff, did you hear that?
Yes, but I'm not actually at my office at the moment. So, Connie, could you please text that number to me and then I can just call it direct?
Yes. Okay, I'll just do it.
Okay.
Okay, while she's doing that, I'll just, it's a little awkward to handle documents in this type of a situation, but I've got a commercial building application here signed by Mr. Cliff. And got another one here, commercial permit worksheet by Mr. Clift, and the date on that is,
April 8th.
okay.
They have it.
Oh, that, okay, there it is.
Mr. Farr, are these documents were not part of your original submittal as part of the appeal, correct?
They were not.
Is there a reason they were not part of that? They seem fairly relevant to the case we're looking at.
I guess I was a little unclear on the procedures. I did mention that in the body of the appeal.
So maybe before we move forward, I am unclear on what exactly is being appealed here. So maybe you could clarify that before we dive into testimony and looking at documents. Can you state succinctly what the decision of the building official was that is being appealed today?
Okay, number one, notice of violation, 120. SMJ General performed work without a valid State of Alaska contractor's license, SOA. Contractor's license expired on 12/31/18. That is true of SMJ General Construction, Inc. But the permit should have been applied for in the name of SM General Construction, Connie Chung DBA SM General Construction, not SMJ General Construction, Inc. that Mr. Clift was used to working with. Because the change came in 2018, probably wasn't accustomed to that. SMJ General Construction, Inc.'s been around for a while. And it was a clerical error. So that would mean that the first notice of violation, of course, yeah, I mean, SMJ General Construction Inc. didn't have a permit. There's no doubt about that. So it was a clerical error. So I'll point out the first one.
Okay, so that applies to one of the notices of violation, specifically about the lack of the contractor license, correct?
This is correct.
All right. Is there more to your appeal than this?
Well, I wanted to have Mr. Clift himself address that, if he's on the phone.
Hello, this is Mr. Clift.
Before you start, Daniel, we need to have you sworn in.
And sir, for the record, before I swear you in, can you state your full name and what your association is with this case?
My name is Daniel Howard Clift. That's Daniel Howard with an H, Clift. I am architect, State of Alaska licensed. I have done business with SMJ and FM contractors, and the best of my recollection, honestly, because
Mr. Clift,
it's been a while.
I want to come in first.
Mr. Clift, before you move on, do you affirm under penalty of perjury that the testimony you're about to give in the matter before us is the truth?
Yes.
Thank you. All right, proceed.
Mr. Clift, this is John Farr. You started to say that you've worked with SMJ General Construction, Inc. in the past?
Well, yes.
Going back to a year ago in April of 2019, did you apply for some building permits and use the name SMJ General Construction, Inc.?
Possibly. Honestly, I can't even recall. It was almost, it was at the beginning of 2019, you say? But it wouldn't surprise me if I was asked to go and apply for a permit that I would go and I would file it under SMJ because that was the construction company who I knew Tyson belonged to, and I don't recall him giving me any other instructions at the time. Connie later informed me on a different project that the name of the company had changed to SM Contractors and I was to lose the J. And after she informed me of this, I did it on all future projects.
Okay, and that was the 3020 Minnesota Drive, Suite 1?
Minnesota, it's on Minnesota. Don't ask me the exact address, but yes, it's in that strip mall there.
In the Wine House?
Correct. But honestly, there was 2 permits filled on the project. One was earlier and one was a repair permit. And, you know, it happened over a year ago. And this is, to me, is a minor detail because I wasn't given any instructions that were pertinent to it. That's the best I can recall.
All right, nobody's pointing the finger at you, sir. We're just trying to get the truth out.
I'm honestly a little bit surprised. I didn't know that a permit could be pulled under somebody whose license was no longer valid under the city's database. I didn't know that they could call for inspections. I'm very surprised by this, actually. Something else happened?
All right. Well, thank you. That's all the questions I have. If somebody else has questions, then they might have some other questions.
Okay, I will stay on the line.
Hearing none. Mr. Farr, do you have more to present on your appeal?
Say again? I'm sorry.
Do you have more of your presentation on the appeal?
Well, I do. That was just number 1. There's 6 here. And we're going through them one by one. We should be fairly efficient at this. We won't waste your time or detain you, folks. But let me ask Connie, SM General Construction is a DBA for you, correct?
SMJ, no.
SM.
Yeah.
Right, SM. SM General Construction is your DBA, correct? All right. And you have a contractor's license?
Yes.
So this should have been applied for in SM General Construction, is that correct?
Yes.
All right, that's what I sought to get from Ms. Chung here. Pardon? Okay, let's move on to number 2. Number 2 is electrical work was performed without an electrical administrator's license, which is a violation of Title 23.10.105.1, Section 2, Paragraph C. All work regulated by this code shall be performed by individuals appropriately licensed in the relevant trade in accordance with state law of this code. And I think Tyson is the general manager for SM General Construction, Ms. Chung's company, and I think he can best explain that.
Yeah, it's Connie, we got mostly general permit after we hire to the subcontractor electric, mechanic, plumbing, and we want to ask them if you guys need to put the permit, please put the permit. And then Victor Electric say we don't have any.
No, hold on. I'm used to Tyson. I've dealt with Tyson for many years, and sometimes I do an English-to-English translation, but that big dog, he's talking about Big Dog. Okay, Big Dog. It sounds a little bit like Vito, but it's Big Dog. Sorry.
Victor Electric is the Robert Smith. He worked with me for the long time, more than 10 years, and after this happening, so we want to ask him, hey, we need a permit. He said, we don't need a permit. Why? Because only light fixture removal is there. We don't have any new power, anything. Okay, if you don't need, you guys are professional electrician. You guys need it. You don't need it. But if you need it, put a permit. even mechanical same thing. We got hired to the diamond meeting. We asking them, this job need a fit, like for the plumbing, and then if not, we don't need it. And after that, everybody say we don't need the plumbing because everything just remove this that. Yeah, anything to the new install to the rooftop unit, new ducting working, just remove this that, and electric power remove this that. So they say they don't need it. But I don't know what's going on right now to the stop the license working. But Victor Electric, they have a license, electric license company. And the Diamond Heating, they have a mechanical license company. But
And that's,
everybody have that to the...
Diamond Heat.
Yeah, everybody have that the license company. I don't know.
And then Mr. Chang is referring to Robert W. Simmons, does business as Big Dog Electric. He should be a licensed contractor. So that's number two. Number three falls under the same point, which is that it says number three, notice of violation number three says mechanical work was performed without plumbing mechanical administrator's license. And that was Diamond Heating, correct? And Mr. Chang told Diamond Heating, like Big Dog, if you need a license, go pull one. And they said, well, the type of work that we're performing, you don't need one. Okay. And then number four is the same thing. Electrical work was performed without electrical permit. That would be Big Dog again, correct? And number five, mechanical work was performed without mechanical permit, which is number five, and that's same thing. Big Dog. Pardon me?
Diamond Heating.
Oh, that's Diamond. Right, Diamond. Okay. And then number six is this one came out late. This was second.
They put it from the penalty of $100,000.
Yeah, the notice of order. This one was the same thing. It was a little bit later one, which was the same violation alleged, which was no permit for a subcontract. And so that's our presentation.
All right, thank you very much. Before we move on, does anybody have any questions? This is a chance to ask questions on the presentation. Hearing none?
May I say one other thing, please?
Yes, you may, Mr. Farr, go ahead.
Big Dog, Robert W. Simmons and Big Dog had a falling out with Mr. Chang. He was terminated by email from Ms. Chung on November 14th, 2019, because he wasn't reliable enough. He wouldn't show up when he said he would and this kind of thing. So on November 16th of 2019, he went and vandalized one of their projects, cut electrical wires and spray painted defamatory comments on the sheetrock and so forth. And so there's been a significant falling out. And I know that Mr. Simmons is actually the one that called in a lot of these violations, alleged violations. Mr. Simmons himself is under charges for multiple felonies that he's been charged with by the state of Alaska. In case number 3AN-20-450CR, they're charged with burglary and assault and a number of other felonies. 3N-20-920CR. He's been charged with felon in possession of a firearm. These charges he was charged with these on January 30th of 20. And he's probably not the most reliable reporter in the world for that reason. The first case was charged on January 15th of 20, and the second case I mentioned was January 30th of 20. So he's still pending those charges. So this is who was doing the reporting against trying to get Mr. Chang in trouble. That's all I have to say.
All right. For two of these notices of violation, specifically the electrical were done without an administrative license, and same for mechanical. You mentioned your subcontractors that had done the work, Big Dog and Diamond Heating, I believe. Do you know if those subcontractors have the appropriate administrative licenses to do that sort of work?
Yes.
They do, according to Mr. Chang.
Yeah, I know that they have a steel license for electric, and Diamond Heating is a big company, and absolutely they have that to the license company.
Okay. Last chance, any questions on this presentation before we move on?
Mr. Chair, this is Bob Dole. May I just ask a quick clarifying question of Mr. Farr?
Yes,
Sure.
Mr.
Through the chair, Mr. Farr, you mentioned several criminal charges. Have any of those been resolved, or are they all still pending?
They're pending.
Thank you.
All right, and with that, I'll turn it over to staff. Please give your presentation.
This is Don Hickel. The 6 items that Mr. Farr brought, the notice of violation for SMJ performing work, for the application, if you could see, I would refer to the building application, which was signed by Mr. Bowden, who is an authorized agent for the construction company, as well as the signature on the permit application and the permit worksheet, which was signed by Mr. Clift. These 3 documents were issued to SMJ, and also all of the permits, when they requested inspections, as well as the architectural review notes, were all directed back to Mr. Chang. And throughout the entire inspection process of this job, there was no mention of SM Construction. The electrical work that was done without a license for Big Dog Electric and Diamond Heating, these entities were known to us after Mr. Chang received his notices of violation. There was no mention of these contractors prior to. It wasn't until the work was completed, the permit was closed, and the notice of violation was issued for the license and the permits, was Mr. Chang telling us that we had the wrong contractor and that it was SM General Construction. Also, I might point out that the bid document from Big Dog Electric, which is not signed, and that document can be found on page 130 and 131 of the submittal documents to the board. And also the mechanical permit bid, which was from Diamond Heating, which is on page 40 and 42, and the payments listed on page 43. All of these bills, all these bid documents are made out to SMJ General.
Mr. Hickle, before you move on, the document that you have up and you're referencing page numbers on,
Yes,
I do not believe that was part of the packet. Am I incorrect in that, or is this
it
We
should,
didn't get this.
they didn't get this packet?
No, it was just happened yesterday. They haven't gotten it.
Excellent.
So this is Bob Dole. It appears that the file that they gathered of all the documents we would normally go over in a hearing with everyone here, they have PDF'd, but they have not sent it out either. So
I don't think we've ever seen those.
They're part of the permit file of the documents that were given to all parties. I believe it's part of the hearing packet, wasn't it?
No, when we gave them the hearing packet 1 week ago, these were not included.
Okay.
Please proceed, and as you reference this packet, be clear or pull up on the screen so that all parties can see and respond to what we have here.
Okay. Go to page 30. Start with page 30, Tana. Whoop. Where are you at?
This is page 30.
Oh, I'm sorry, page 40. There's Mr. Bowden's name. Is it back one page, Tana? Go to 39. I think it's back one. No. Okay, use the arrow buttons on the top. Go to page 40, 41. There's these are the bid documents from Diamond, adding these 6-inch supply airs to the mechanical system that was installed prior to them obtaining their permit. Go to the next one. There's the heating, there's the bid, September 10th, SMJ General. Okay, Tana, can you go to page 130, just type in 130 where the 42 is there?
130?
Yes. This is kind of tough to see. This is the bid proposal from Big Dog Electric from Mr. Simmons to Connie Chung for the wine house. Scroll down. And then we can go to page 131. And this, the dates of these is in January. Well, maybe not January. Go back to the next page, please. We can get the date off it on the previous page. I thought this was... No.
This one.
There's no date on it for the bid proposal. And but it's not signed by Mr. Simmons either. These are bid proposals. So I don't know, there was a mention that Big Dog Electric had made had notified the city of this work, and that's not true. The field inspection staff had notified Mr. Chang of the notice for the mechanical permit for the building and the electrical, We had no contact with Big Dog Electric or Diamond Heating prior to the notices of violation going out.
Gentlemen, it sounds like we have a sidebar conversation going on here. Is this related to the presentation?
Well, it is. It is.
Is there any questions?
Yeah, this is Troy Feller. I have a question. I'm kind of confused on this whole thing. So the fines are against SMJ, but SMJ is bankrupt. So I don't even, what's the issue? I mean, the municipality is trying to fine a company that no longer exists. Is that true?
So, through the chair, this is Bob Dole, the building official. The action, the enforcement action was named against SMJ Construction and its principal, Tyson Chang, for the action that occurred there, for the actions involved in this. The solvency of the company and or the individual is not relevant in terms of, we believe staff can show they were the ones responsible for the actions here.
Okay, and the other question I have, I guess I'm not clear, there was a certificate of occupancy issued, and then these fines happened after the CO was issued, is that right?
Well, the final structural inspection that issued the CO was on September 16th with pending the application for the mechanical permit. 3 days later, they SMJ closed the permit, and it was actually closed in error by our department because the mechanical permit was never issued, neither was the electrical.
Through the chair, this is building official Bob Dole. Under IBC provision 111.4, the building official or his deputies has the authority to revoke a certificate of occupancy or other document that is issued in error. This one was issued in error because the electrical and mechanical work had not been resolved, which is why it was subsequently revoked upon, although the structural part had been completed, the other parts were not.
Okay, this is Troy Feller again. So you said the CO was issued pending the mechanical work. Was that on
Yes.
the permit?
Yes.
That was on the CO? Was pending resolution of the mechanical work?
31. Yes, it's on page, she can pull it up here. Whoop, you go too fast. Scroll up. There you go. You gotta scroll down a little bit, Dan. Right there.
Okay, thank you.
Mm-hmm.
So through the chair, this is Bob Dole. When a permit requires different disciplines to sign off on it, one discipline will indicate their discipline is completed or approved for CO, as you saw there. The error occurred and they're not looking beyond that for the note that the other ones were still required to be addressed.
Okay, Troy, another question from Troy Feller. So, does building safety check that a contractor is licensed when they apply for a permit? I mean, it sounds like you don't, because this contractor license was not current when they applied, is that right?
Through the chair, this is building official Bob Dole. What happens is an individual or a company applies for a license. At the time they apply, we confirm that they have a state license, and then we issue the Muni license. If they do not notify us, we do not find out that their state license is no longer in effect, and thus their Muni license is not valid until the next time we go for renewal. But at the time SMJ Construction applied for their Muni license, they had a valid state license that subsequently lapsed. But there's no tie-in between the databases. It's all done manually. Normally entities advise us when they no longer have a state license, so that the Muni license is not valid. We did not receive notification of that or the bankruptcy in this case.
Okay, so even if you had checked at the time that SMJ applied for the permit, you wouldn't have known that their license was no longer in effect because there was no notification.
Through the chair, they would have, we would have flagged it in the system upon notification, so they could not have applied for a permit in SMJ Construction if our records did not indicate they had a valid Muni license. Just the system would not have let them use that name to apply at that point, and this would have been flagged. So we do not check the state licenses every time somebody comes in for a new permit.
I have a question. This is John Barr.
Go ahead, Mr. Barr.
If Mr. Hickle is still answering questions, the notices of violation were all issued to SMJ General. They were not issued to Mr. Tyson Chang individually, correct?
I believe so.
That is correct.
That is correct.
That's all I have on that.
In that, this is Troy Feller again, another question. So, I mean, if a company's filed bankruptcy, but is building safety is saying they want to go after these fines from Mr. Chang personally, but the fines were levied against a company that has gone bankrupt. What are the legal ramifications with that? I'm not sure.
Through the chair, this is Bob Dole, the building official. The Muni attorneys can chime in if I'm off base. When we assess fines, we assess them against the company and also the owners of the company, of which that was Mr. Chang at the time. He also, at the time that these actions occurred and the company was no longer existing, he was doing business as the company. So in effect, he was using its name, so he would assume the liability of the company. Is our position on that.
Yeah, I don't agree with that legally, but anyway.
Yeah, I mean, the way I understand it is when you incorporate, if you're a corporation, then the owners aren't personally responsible for a debt like this. But I'm not a attorney. I don't know that, but that was my understanding.
We do not assess this as a debt or a fine owed, but rather it's not a debt but a fine against both the principals of a company that violates the building code as well as the company itself.
Yeah, I mean, I have to chime in here. The notice of violation says SMJ General. It doesn't say Tyson Chang. Tyson Chang also has been discharged in bankruptcy. SMJ General Construction Inc. is still in bankruptcy. It hasn't been fully administered yet, but the Mr. Chang himself filed for bankruptcy at the same time, which is 18-341, and he got a discharge last fall. But as far as a matter of due process, if the fines are against SMJ General Construction Inc., there is limited liability, and there's no evidence that he was doing business as SMJ General Construction Inc. That would be an actual question that hasn't been supported.
Through the chair, this is Mr. Dole. Can I ask Mr. Hickle a few questions?
Yes, please, go ahead.
Mr. Hickle, how were you able to determine that SMJ General Construction was the entity that was involved in this beyond the initial application by Mr. Cliff? Were there actions by others that were consistent with SMJ General being the one that was doing the work on this project?
He was the point of contact
He was the point of contact for
all the inspections. He was the point of contact. It's listed in the architectural review comments that were issued by Plan Review, and he was the point of contact not only for the structural inspections that were performed on the project, but he was also the point of contact for the fire inspections.
Mr. Hickle, to clarify, can you, for the record, state who he is?
Tyson Chang, I'm sorry.
Thank you.
This is Bob Dole again. So Mr. Chang received these reports. Did he ever indicate that there was the wrong company indicated on it?
No.
One of the earlier documents you showed us was signed by Mr. Bowden. Who is Mr. Bowden, to your knowledge?
To my knowledge, Mr. Bowden is an authorized agent who's able to apply for permits. He's signatory on the SMJ account and SM General.
So at the time that, did Mr. Bowden on that document apply as SMJ?
He signed the permit application to SMJ General Construction. Mr. Bowden's signature is on the bottom of that page.
And Mr. Hickle, do our records indicate we were ever notified that either Mr. Chang or SMJ Construction had filed for bankruptcy and there were proceedings ongoing in bankruptcy court?
No.
Well, this is Troy Feller again. I guess I have a question of the appellant. Why are you appealing this decision? Just let the municipality go after these fines from SMJ, which is now in bankruptcy, and I don't see, and to me it stops there. So why are you appealing this?
Well, I think it's holding up a certificate of occupancy. It was revoked, if I'm not mistaken. That's what we just heard, anyway.
Okay. I didn't understand that. Thank you.
But other than that, you're right. Pardon me? Yes.
So the municipality will not issue the CO until these fines are resolved? Is that where it's at?
Through the chair, this is Bob Dole. I will start in with Mr. Hickle to provide the specifics. The municipality will not issue the CO till the other permitted work is addressed. It's axiomatic that the general contractor remains liable for the work of the subcontractor working under him. Those subcontractors are not with us. We still have the unresolved work that has not been done or permitted, inspected, and signed off. It is not just a matter of the fines, but rather we have work that has not been addressed either.
I have a question for staff. If this were a case where a third-party general contractor was doing the work and had gone belly up, and the owner needed their CO, what steps would the owner need to take to correct this action?
Change of contractor. They'd have to fill out a change of contractor form that would be signed by the owner and the new general contractor, or whoever the permit holder was, and the new general contractor, and have it notarized and brought to our office, and we would change the contractor.
Is this business Wine Styles associated in any way with Mr. Chang or Mrs. Chung?
I do not know. The building is owned by Ihis. We don't know. I don't know who owns the wine house.
I mean, so who's being harmed by this right now with the CO not being issued?
Well,
the building owner, right?
the building owner is, they don't have a certificate of occupancy. I think their insurance company would be very interested in something like that if something were to happen there. And the mechanical and the electrical permits are still open on the building. And it was open for business, right? You know, it probably still is open for business during the pandemic.
Another question for staff on the notices of violation for electrical or mechanical work performed without an administrator license. Is that sort of notice typically levied against the general contractor and the subcontractors off the hook, or how does the sub get roped into their accountability for this sort of thing?
There was no subcontractors at the time of the notice of violations were issued. There was no permits applied for. And the work was completed. So he's kind of, to us, the mechanical and the electrical work was completed, and we hit him with the notice of violation, and since then, the mechanical permit was applied for through Diamond Heating, and the electrical permit was applied for. It's never been obtained. I mean, you gotta remember the scope of the work on that wine house. They completely removed the RTU unit to replace all the trusses in that building, and then resheet the roof, reinstall the roofing, the roof curb, put on the RTU unit, rewire, and redo the mechanical supply and return air system within the store.
Excuse me, sir.
Can Mr. Chang address?
This is you guys have some complete wrong information. This is a wine house. The truss damage is only half of the building, and we're not going to remove anything to the rooftop. And the half of the side, we still using the ducting system. You need to just change to the one line, the duct and the front entry. Other than that, we're not touching anything. Electric is we just remove the ceiling light and disconnect to the power of the rooftop unit, disconnect power to the working cooler, and other than that, any outlet, any switch, we're not going to move anything. We just remove to the ceiling light and then disconnect power to the rooftop unit, disconnect power to the working cooler. After we completely replace the truss, half of the building, not the whole building. So after that, electrician, they hook up to the power, back to the power, was tied up. And then Diamond Heating, they came in, we want to put the old ducting system, but there is the damage to the duct. They say, hey, actually this is no good. You gotta replace the new one. I said, okay, just put the one line to the next new one. and they just came to the one line to the original, almost the same thing. Other than that, not touch anything, sir. No gas pipe touching, no water line touch anything. We just remove disconnect the electric power and put the back. Do not touch anything to the rooftop unit, sir. That area is not damaged to the roof.
Can we get an interpretation, please?
Okay, maybe Ms. Chung can address that.
So, this is Connie with SM General. So Tyson was saying that the only things that were done in the White House was we did not reinstall a rooftop unit. Only half of the building rooftop structures were damaged, and so we did was we just put up the power to the lights, the walk-in cooler, and the RTU units, and then after the testing was fixed, we reconnected the lights as power to the lights and the walk-in cooler and the RTU. The only additional repair that was made to the rooftop unit was one of the test lines. It was damaged and we could not use it, and so we had to replace that exactly as it was. So we did not change any of the original design specs of the building, of the unit. That's what Tyson was saying.
So this is Troy Feller again. I've got a question for I guess staff. I mean, what's it going to take to, especially for the electrical portion of this work, since that subcontractor is obviously not going to be doing anything. I mean, by that I mean Big Dog. I mean, so what's the way forward to get this work approved and permitted? Is it to have a licensed electrical contractor come in and inspect it, and then have you guys do your inspection, and then it gets signed off? Or what's the way forward on this?
Well, first get the electrical permit issued, you know, like you said, and get it inspected. And we have been waiting for, we were expecting to do this last fall when Heath gave him the CO. You know, like they said, the roof was open on the unit, and Heath Kallstrom, the structural inspector that was on the job, would not have written him up for a mechanical permit and mentioned the RTU if the RTU was sitting on top of the roof. And according to my inspector, it was in the parking lot. The electrical work that was done in there for all the surface mounted electrical, removing that amount of the roof, you know, we want the building safe too. We want the business to be open. It took him from September to January just to start the permit process after he was hit with the notice of violations.
So, you know, on this CO, the only note is a mechanical permit and inspection is required for attachment of the RTU, the rooftop unit.
Right.
That's saying, you know, the only thing needed to close this out, or the only thing that's still pending, is to tie the rooftop unit down to the curb.
Right.
And then a CO was issued and then revoked. This thing's just, it's a mess.
Well, the final structural was approved pending him getting the mechanical permit, which he told my inspector he would do, and that's not unusual for us to do that sort of thing. If the guy's going to get the mechanical permit, we're not going to hold up the structural side for the CO to come back and do another inspection. When Luke went out and did the notice of violation for the no mechanical permit, because that's an exposed ceiling in there, that's when the electrical work that was done without a permit, because it's all new MC cable, that's when that was brought about. So when Heath did his final, I can't speak for Mr. Kallstrom, but I think we can all agree that a ceiling that's painted flat black and the entire thing, because it's an exposed structure, I think we would all notice new MC cable that was ran in the building. Now, I can't say that it was or it wasn't, or if Heath didn't notice it, but it was certainly picked up by Mr. Cleat. Can you
So another question for staff. What I hear the appellant, you're kind of making the argument that the electrical and mechanical work was pretty simple. They basically just disconnected some things and then reconnected them. When does that work become so straightforward and simple that you don't need a permit for it? I mean, the subcontractors were both telling the general contractor that a permit was not required for this work. I know, there's I've heard of like a $5,000 limit. If it's more than $5,000 worth of work and it's commercial, a permit is required. But when does the work become so minor that a permit's not really necessary?
The requirements for permits are found in the administrative code in section 104.1 for permit requirements. Any owner or authorized agent intending to construct, enlarge, alter, repair, move, demolish, or change the occupancy of a building, structure, or portion thereof, or to erect, install, enlarge, alter, repair, remove, convert, or replace any electrical, gas, mechanical, or plumbing system. The installation of which is regulated by this code, or to cause any such work to be done, shall first make application to the building official and obtain the required permit unless the work is specifically exempted by the code.
Okay, well, so what I just heard, alter, that covers just about anything.
Yeah.
I mean, there's got to be some reasonable limit. If someone's going to come in and, remove a wall receptacle and replace it with a new one, I mean, you don't pull a permit for that. So I guess I'm asking, practically speaking, when is the work of such a minor nature that, reasonably a permit would not be required? And, is this project approaching that level of work?
Through the chair, this is the building official, Bob Dole. The code specifically has other sections that list work that does not require a code, or does not require a permit because of the de minimis nature of it. We did not cite those sections because they weren't applicable to the work done, but there are separate ones that talk about replacing the outlet or the minor things like that you're talking about.
Okay, in your opinion, this work that was done for this project does not fall under that diminutive nature?
No, they're specifically spelled out, and this is beyond it, as evident by both the new materials Mr. Creech here can talk about he saw on the site, or it wasn't scope specifically identified within the admin code.
All right, thank you.
I have a comment. This is Connie from SM General.
Go ahead.
So as a general, because we are not experts in all trades of construction, the reason why we hire subcontractors in electrical and in mechanical is for their expertise. And if they require a permit that needs to be pulled, because we hire them on as subcontractors, we assume that they have that knowledge, that if something needs to be repaired that requires a permit, that they should go and pull a permit. So, and I was talking with James a while back, the electrical subcontractor Big Dog that we had hired, they were not getting fined or anything like that regarding this project.
Who's James?
James Bowden. Yeah. And so I guess my comment is, we hire subcontractors for a reason, and because we're not experts in that trade. And if they fail to pull permits, is that on the general?
You're the party in responsible charge as the general contractor. You're responsible for your subcontractors. Right?
And this is Bob Dole. For the record, that was Mr. Hickle who just said that.
Sorry.
So, Mr. Henkel, previously, when I had asked a similar question, you stated that there was no action against the subs because at the time, in the view of the municipality, there were no subs.
Correct.
Would that have been different if you had visibility to work that had been done by the subcontractors?
If they had subcontractors that had pulled permits, they'd be talking to the mechanical and the electrical inspectors. The bid proposal that we showed earlier on page 130 from Big Dog Electric, in his exclusion, the first thing he cites is permit fees. That was in his bid proposal. And again, I don't see a contract here from Big Dog Electric, and it's neither here nor there. We never got an electrical permit. We never got a mechanical permit. And in fact, on September 12th, Mr. Kallstrom again asked Mr. Chang to get a mechanical permit. That was his first notification for the RTU units.
This is Troy Feller. I've got another question. So, I'm a structural engineer, and I don't have any expertise in mechanical and electrical, but this is a question to staff. Is the mechanical and electrical work that was done for part of this project and not permitted and inspected, is this putting the public in, could this be putting the public in danger?
Absolutely.
Okay.
Any other questions for staff at this time? All right, our next step is the appellant has the right of a rebuttal. We've been talking back and forth a little bit, but this is your chance. Do you have anything else you'd like to say at this point?
Well, I'd like to ask Ms. Chung, Ms. Chung, would there be a reason why Tyson Chang would be point of contact?
Yes, like the project manager for all of the projects under SM General Construction. And so every single project, he is the point of contact.
And then Mr. Chang, did you try to explain the situation that we're facing the appeal on to Mr. Creek? You explained that SMJ was...
I said to him, I think just a simple mistake, because it's SMJ is a normal business, maybe S10. Yeah, maybe mistake to fill out this paper. So we need just one letter mistake and just clean out the easily go, not to this much far away. And I sent him 2019 already, I don't have any more business. And he said, yeah, I understand. Simply fix just one letter. And then I sent him, maybe your crew mistake or my crew mistake. Even we didn't see that to the building permit, SMJ. We didn't look at any we just put the permit, oh yeah, it's supposed to do the permit. We didn't mention to the executive letter to the SMJ. So I took a look, and then after that, he said, okay, Tyson, your penalty 10,000, and then next day he said, oh, 100,000, and after a week again, and 150,000. Hey, wait a minute, why you guys keep going charging me to the $150,000? Previous penalty, yeah, SMJ previous penalty, I'll pay them too. And I talked to them, the Muni, hey, I'm not going to go anymore to the violation. So I will exactly step the rule. So I stepped the rule. He said, first time it's around 1,000, 10,000. Next day it's 100,000 and 150,000. I said, hey, look, calm down. This is only a one letter mistake.
One letter is the difference between SM and SMJ.
Yeah, just a simple mistake. And why you guys charge me $150,000 and mess up the case? It's not a big issue. If we need it, yeah, we call the electric permit, we put the mechanic permit, we go inspection. That's why everybody happy. Why you gonna mess it up? And then I explain to you guys, we do the same thing. I'm general, because almost 20 years, but I'm not professional. I didn't know the subcontractor rule and electrician rule, mechanical rule. And mostly I know that the mechanical electrical license, admin's license guy, hey, this is under his license, he can handle it. I said, okay, I give them job. Even they need a permit, yeah, I pay them to the permit fee. So mostly, right now, the MOA changed the rule, general pay the full amount of the permit fee. So, any subcontract, they need a permit, they just got the permit, that's it, they're not going to pay anything. So, we asked them, hey, you guys are professional, you guys need it, but take out the permit. You need it, you don't need it. Just to get a trust pickup. Just a simple mistake, just one letter. And if you need a reinspection for a reinspection.
Let me add one other thing, which is that the way it works in bankruptcy court, if a corporation files bankruptcy, the corporation does not get a discharge. The bankruptcy trustee administers the debts and pays the assets such as they are to the creditors. However, the bankruptcy trustee and the bankruptcy court will not allow a company, a corporation or an LLC just to file bankruptcy and get rid of its debts and creditors and then continue on in business. So SMJ General Construction Inc. Is really legally precluded by the bankruptcy code from continuing in business. And so satisfied the bankruptcy trustee that he was out of business. And so that's the way it works in bankruptcy. That's all I have.
So this is Troy Feller again. I've got a question for the appellants. Is Mr. Chang an employee of SM General currently?
Yes.
Okay, and the appellant is Mr. Chang, and what he's appealing is that the permit should have been applied for by SM General and not SMJ. So if we grant the appeal, then this whole problem becomes SM General's problem. Is this, so Mrs. Chung, is this what you're trying to achieve?
What we want to achieve is just to solve this problem. Like, how do we, exactly how you were saying, how do we move forward? We want to make things, what steps do we need to do that?
Well, and if I may, the reason the CO was revoked, we were told, was because of the unpaid fines, and then Mr. Dole said it's because undone work. But if the work wasn't done, those CO would have been erroneously rendered in the first place, seems like. And so I guess we're just talking about fines. And if the officials turn around and, well, let me back up a little bit. The appellant is not Tyson Chang. The appellant is SMJ General Construction, Inc., not Mr. Chang personally. If the officials turn around and give notice of violation to Connie Chung, DBA XM General Construction, then we will have to deal with them at that time. So that's how I would address that.
Well, so the appeal form is signed by Tyson Chang, and the name's actually spelled wrong, appellant. I mean, that's the appeal form. That's what we're here discussing. Is that, am I wrong?
Well, it says Tyson Chang / SMJ General Construction. It's, he was the owner of SMJ General Construction. So that's why it has his signature line on it. But I mean, the notice is...
But at the time you signed this, SMJ Construction was no more, and I'm talking about the actual appeal form. It says, and maybe this is splitting hairs, but this thing is just so messy, and there's been mistakes made on both sides, and I'm just trying to figure out how we solve this with the least amount of pain to all parties involved. But
I understand the intent was for the entity to which the notice of violation was issued, SMJ. It just says SMJ General here. And Tyson Chang owned SMJ General Construction, Inc. So anyway.
But I mean, this is Troy Fagan. I mean, we are here to either grant the appeal or not. And the appellant is Tyson Chang, and the appeal is that it should have been SM General and not SMJ for the permit application. I mean, so that's how I see it.
Well, Tyson Chang would never come into it per se. I mean, if I didn't fill out the form right, I mean, I've never been good at filling out forms, but it really, the notice was issued to SMJ General Construction, or just SMJ General, and then Tyson Chang owned it, and so that's the way I prepared the form.
Okay, I understand. Thank you.
Other questions at this point?
Yeah, this is Keith Sobolewski. I have a couple of questions. I just
Go
want
ahead.
to clarify, is the MOA decision and the subsequent appeal about this C-19-1404 permit specifically?
1407.
That came through a little garbled. You couldn't hear that hardly.
Sorry, I'll repeat myself. Is the MOA decision and the subsequent appeal about the wine store permit specifically, permit number C19-1407?
This is correct.
Okay. And I have another question. So there is an inspection report that's up on the screen right now. If you could scroll down, it does cite. This is a report that cites the necessity of a mechanical permit and would be a notice provided to the general contractor. Correct?
Yes. Is
there one that is also citing the necessity of an electrical permit?
I do not believe so. There's only 2 structural inspections performed on the site. The other one is found on page 30. And, that's fire. 31, go to 32. Sorry, Dana. You gotta scroll down. There's the other structural inspection there. That was on the 12th. And there the RTUs were removed.
And this is Troy Feller. I'll point out again, the only thing this is really referencing is just, it's the attachment of the rooftop unit to the curbs, kind of like I mentioned before. And that, I mean, that's the only note.
Right, because he removed, the rooftop unit was removed. He took it off the roof.
So this is Connie from SM. Tyson just drew me a picture. So this part of the building was perfectly fine. This part of the building was where the trucks were damaged. There was an air compressor. Walk-in cooler air compressor here. RTU was on this side of the building, and then another air compressor here. The air compressor was the one that was removed. The RTU and this side we did not work on at all.
Oh, ma'am, I can only go by the inspection comment.
Well, someone else earlier said the rooftop unit was sitting on the ground at one point.
Yes, that's what the inspector said. And he states it there in that inspection. The RTUs were removed and reinstalled to accommodate the new trusses. Granted, my structural inspectors are carpenters. They are not mechanical engineers nor contractors, and they don't know the difference between a RTU and a compressor. You know, he saw the unit on the ground, and it had a curb that it sat on, you know.
I mean, so this is Troy Feller again. I mean, the point I'm trying to make is attaching a rooftop unit down to a curb is a pretty simple thing, and if that's all that was required, we wouldn't be here talking about this, because that's easy and inexpensive to do. And that's the only thing noted on the CO, and then the CO was issued and then revoked, and now we're bringing electrical into it, but that wasn't noted on the CO, and this is just...
Well, I understand that. When Luke could speak to the issuance of the notice of permit requirement for the electrical portion, he was there. Luke?
Yeah. So when I got on site, this is Luke Cleek, Code Abatement Officer. So on 10/21/2019, I made a site visit to investigate some unpermitted work that came through on the Dynamic Portal, which is a computer program that we use to facilitate inspections. So while on site, I noted that there was large amounts of electrical work that had been taken down, stored, and then reinstalled without an electrical permit. This activity does not meet any of the permit exemptions that are listed in 2310-104. And I ran my findings by electrical lead Victor, and explained to him the situations and what my observations were, and he stated that indeed even merely disconnecting all the lights, bringing them down, storing them, and reinstalling them is the same as new work, because the electrical is disconnected and reconnected and requires inspection in that process.
I think the rules changed on that.
Whatever, my point is right now to the, penalty, SMJ is already saying that if they want to charge, it's okay. But for mistake, you need to put a permit, you got hired to the electrician, you got hired to the whatever diamond gives, okay?
All right, this is This is Sterling Strait, the chair. I'm going to make a call on this that we're pretty far into scope creep territory here as far as this appeal is concerned. The appeal form itself specifically appeals the decision regarding the general contractor concern, the first notice of violation. All these other issues get much more into the mechanical electrical side of things, which is not the expertise of this three-member panel. We were pulled together for an administrative question based on what was on the appeal form here. So I would like to propose that we dial this back and we address this first issue, the notice of violation about the lack of a contractor license for SMJ General versus SM General. And these other issues that have come up through this discussion, I don't believe we should be addressing them now. I don't believe we have the expertise or the data to back up the discussion here. We're talking about a lot of things. We have a 238-page document on the screen here that we have not had a chance to review prior to this meeting. So I'd like to propose that we dial this back to only the administrative issue. Troy, Keith, what do you think about that?
This is Troy. I think you're spot on, Mr. Strait. That's what we need to do. That's what we're here to deliberate. So.
And this is Keith. I agree too. We don't have enough information to render any decision regarding the mechanical or electrical issues.
All right, thank you for that. With that, we're going to move forward along these lines. So are there any further questions for the appellant, specifically regarding the administrative issue?
We don't have any questions, thank you.
I have one I'd like to ask, and that's, at this point, it is a matter of somebody, we're going on somebody's word that the incorrect general contractor was put down. What about the contracts between the contractor and the owner? What about different documents? Is there any documentation that backs up the claim that this work was truly an SM General project and not SMJ General?
Well, this is Connie from SM General. When the roof collapsed, the owner of the building filed a claim with the insurance company, and they received a check from the insurance company.
Who's they? They received?
HSA Investments, which is the building owner, received a check from the insurance company, and in turn, HSA Investments wrote out a check to SM General Construction, not SMJ, for the work.
Can you speak to the, again, from the document that we have not seen other than what was shown on the screen, can you speak to the fact that the subcontractor bids that were previously displayed were both written out to SMJ?
Because Tyson is like our project manager, like I mentioned, for all of our projects, people know him and associate him with SMJ Construction. And because they've worked with him for many, many years, and I think there was just I can't really, it's just, says he's worked with companies for over 30 years, and I think that it was just a mistake on everyone's part. That's all I can really say.
All right, then the last question I have, we've kind of talked around this issue, but if we grant this appeal, what is the end result here? Is it the notice of violation against SMJ goes away, or is this transferred? Maybe this is a question for staff. What's the result if we grant this appeal?
Okay, excuse me, Sterling. I've been asked to show one page before you asked that question. What page was it?
134. It's got the check on it.
Let me scroll down here.
Yeah.
Okay, there we go.
There's the check she was talking about.
Yes. SM General Construction.
That's the demo.
All right, and to staff, can you answer the question of if we grant this appeal, what exactly does that mean?
This is Bob Dole. In terms of the CO, it means absolutely nothing. The electrical and mechanical work is still open and unresolved at that point. So that work is still unpermitted work. So the CO is still out there and beyond the scope of this appeal. In terms of the liability that may exist between, I guess it'd be a credit now, between SMJ Construction and those subcontractors, a credit they'd have to put before the bankruptcy court for actions they have against them. Those are civil actions between SMJ Construction and, or I guess it's trustee at this point, and the subcontractors that they have issues with. The property owner's work still remains unresolved in that regard. Granting the appeal would then shift the liability onto SM Construction and new enforcement actions to the extent work was done, because they remain liable for the actions of their subcontractors.
I have a question, Connie, with SM General. If the liability transfers, do the fees remain the same?
Well, and then I have a question about quote-unquote liability transferring. If there's going to be notices of violation against Connie Chung, EPA, SM General Construction, then the notices of violation should be reissued and give her a chance to appeal those. So there should be a whole new appeal right there.
In the interest of time, I'm going to go ahead and cut off this conversation because this goes beyond, again, what this appeal panel can deal with. I would ask that if we do go that route, that you have that conversation with the building official to determine what happens with these other items. Does that sound fair?
Very well.
I don't think we have the people here who can resolve that. All right, I'm going to go ahead and close the question point of this.
Excuse me, I have one more. This is Keith. I have one more question for.
Okay, sorry. Go ahead, Keith.
For Connie, is it your understanding that the permit in question should have been filed under SM General Construction?
Yes.
All right. With that, I'm going to bring the rebuttal to a close and the questioning period to a close. Now is the point of discussion for the three-member panel. And to start that off, do I have a motion to consider?
Yes, this is Troy Feller. I would like to make a motion that the appeal be granted.
This is Keith. I will second.
All right, discussion.
So this is Troy. It just seems very simple to me that it seems like a mistake was made, and an employee of SM Construction is the appellant, and they're asking for that the permit be changed from SMJ to SM, and then the effect of that, it seems to me, is it becomes SM's problem. And what Mrs. Chung said is, yeah, that's it, and that's what they're trying to achieve. And so it seems pretty simple. We grant the appeal, and now the problem, and SMJ is no more. They can't really deal with the problem and do whatever needs to be done to get the CO issued, because they're no longer a corporation. SM is a corporation, and they will be able to move forward and get this thing resolved. So based on that, I think it's pretty clear we just grant the appeal.
Keith, anything else to add? Any other thoughts?
Not especially. I just agree that it seems like that there were a lot of people involved who are involved with both companies, and it was quite possibly just a mistake made between the two.
And I agree as well. Especially with the check that we're looking at on the screen now, that's the evidence that backs up the claim that it's SM General that's been doing the work. And a one-letter mistake on permit form has caused us a lot of trouble. So I'll be supporting the motion. All right, and unless there's any further question, I'll go ahead and call the question. So all those who support the motion, please say aye.
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 This is Keith. Aye.
And any opposed? Any abstaining? All right, let the record show that appeal BCA-03-2020, building official decision of notice and order and notice is a violation of license. Specific to the question of who the general contractor on the form was, all I have to say, we have granted the appeal.
I would like to amend that by saying for specifically permit number C191407.
Yes, thank you. Did we do that right?
You did.
Okay. And that brings to a close item number 2, new business. Next on the agenda, board member comments. Any final closing comments, gentlemen? Hearing none, do I have a motion to adjourn?
Well, I do.
Sorry. Go ahead, Troy.
Well, this would be comments concerning old business, or just I would like to make a comment regarding this whole proceeding, if I could.
Please go ahead.
And you know, like I've said before, it seems like mistakes were made on both sides, and now that this is SM's General's issue, I mean, I would really like to see the immunity work or building safety work with SM and just get this solved and not have it be an adversarial situation where the building safety is trying to collect a bunch of fines and holding up a CO. You know, let's be reasonable and just get this thing solved and get the CO issued. The mechanical and electrical work seems pretty minor, and I would just like to see the two parties, being building safety and SM General, work together in a non-adversarial way to solve this problem, and that's my comment.
This is Keith. I have another comment, which is just to the effect of if there is information that's going to be brought to the hearing, it would be really nice to be able to have an opportunity for both the panel members and both parties involved to review it before the hearing.
With that, Keith, I do apologize. Unfortunately, you got brought in the last minute due to a conflict of our other board member. So, unfortunately, this was postponed 3 times due to COVID. And unfortunately, all of the materials were not put together. The appellant did not bring much materials in. And there were no actual conversations between us to get clarification. And as for staff, unfortunately, I did not receive the PDF file until Monday when I created it.
And this is Bob Dole, the building official. This is our first attempt doing this electronically, where normally when either party had a question, we would have the file there for the board and the members to go through. You all just did the guinea pig round/science fair project of how to do these hearings electronically. We have a lot of lessons learned if this becomes the new normal, which it may very well in terms of how we do these.
Fair enough, understood, just wanted to make that a point.
Thank you.
All right, and my final comment would be to thank everybody for their time and appreciate the meeting pulling this together and figuring out a way to do this electronically so we can make this happen.
We would like to thank you for their time also.
Thank you.
Thank you.
Thanks.
Thank you.
All right, do I have a motion to adjourn?
I will propose, this is Keith, I will propose a motion to adjourn.
Excellent, do I have a second?
Second.
All right, I think that means we're done.
All right. Thank
Be
you.
safe out there and wash your hands. Thank you guys very much.
Board members, please stay on the line. I have one thing to tell you.
Okay.
Okay?
Thank you, everybody else.
Thank you.
You can hang up, Mr. Farr. Thank you. Okay, Troy, Keith, and Sterling, I will prepare this tomorrow morning, and I will email it to you. Give me comments if you want any corrections or additions, and then through email. And otherwise, if you're good with it, you can go ahead and sign it and move it on to the next person.